Hello everyone, my name is attorney Harley Gordon, the principal creator of the CLTC designation. Your instructor has asked for my input on Medicaid. This is my area of expertise, and I found throughout the course that this is the most popular part. Medicaid can cause you a lot of issues if you don't understand how it works. Now, as we've done with self-funding, Medicare, and the VA, we solicit what the client thinks will fund the plan you've just created to protect his or her family, and we put it into a statement. Frank, now that you understand the plan and agree it's important, the next question is, what do you think will fund it? One of the most common objections is, of course, Medicaid. Medicaid will pay for my care. Now, a reminder of the two goals of the plan. There are two goals. First, it's to allow the client to remain safe at home while preserving the emotional and physical well-being of those the client loves. And second, it's to allow the client to keep financial commitments. What you'll quickly notice is that Medicaid cannot be a viable funding source for that plan for the two reasons we're going to explain. First, it's not a viable funding source to pay for care in the community. And second, Medicaid is not free. Now, perhaps no other objection to the purchase of long-term care insurance has caused insurance producers to respond more inappropriately than the issue of Medicaid. To malign this program for the express purpose of selling long-term care insurance in any form is counterproductive, particularly when the client has been told by an attorney that he or she can get benefits essentially free of charge. It is also not in your best interest and untrue to be derogatory of nursing homes that accept Medicaid payment. Regardless of what you've been told, here are the facts. There is no difference between a facility that takes Medicaid and one that does not. If a nursing home has an inferior reputation, it does so whether or not it takes Medicaid. If you doubt this statement, think of skilled nursing facilities run by religious and fraternal organizations. They are universally thought of as providing first-rate care. Here's the point. Every one of them takes Medicaid. Here's another thought. Nursing homes rarely discriminate. Statistically, 90% of permanent placements started as referrals from hospitals for skilled or rehabilitative care. Skilled nursing facilities do not ask hospitals for financial for those referred because it's illegal and impractical. They would not get many referrals. The flat fees paid by insurers put pressure on hospitals to discharge patients as quickly as possible. By the way, we covered that under Medicare. Skilled nursing facilities are interested in taking these patients because while they lose money on Medicaid, they make up the difference with Medicare Part A and private pay. There are far more skilled nursing facilities than hospitals, so if skilled nursing facilities conditioned acceptance on financial viability, it's actually the case that few hospitals would send their patients. Now, as we'll demonstrate, when Medicaid is explained correctly, it ceases to appear as competition to long-term care insurance and actually helps you sell the product. Let's start with a review of Medicaid versus Medicare. Because of the similarity of their names and common history, Medicaid is often confused with Medicare. Their roles in funding extended care, however, are quite different. Both Medicare and Medicaid pay for skilled and/or rehabilitative care. You learned that when you had that discussion about Medicare. But let's look how they differ. Medicare is funded by taxes on participants. There's no federal or state participation. Medicaid is funded by both the state and federal governments. Medicare does not cover custodial care. Medicaid covers custodial care, but primarily, the operative word is primarily, in skilled nursing facilities or nursing homes. Medicare is an entitlement program. You're entitled to it, you paid into it. Medicaid is a means-tested program. You have to have insufficient assets or income. The home and community-based service versus the PACE waiver programs. Now, I discussed that Medicaid pays almost exclusively for care in a skilled nursing facility. However, Medicaid does and will pay for care in the community, services at home, adult daycare, and assisted living under a federal waiver program for which states may apply. Now, there are two programs. The first is the Home and Community-Based Services, or HCBS program. For those that are 55 or older, by the way, HCBS are for those under 55. For those over 55, it's referred to as the PACE program, or the Program for All-Inclusive Care for the Elderly. Now, at first glance, it appears that Medicaid would be a formidable competitor because they do pay for custodial care in the community. However, a close look proves just the opposite. Let's take a quick look at criteria for eligibility. Assets for an individual, generally under $2,000. Let's stop here just for a second. These numbers are general. You need to check with your state, and the best way to do that is to go to a local Medicaid enrollment office. So assets have to be under $2,000, and income, generally, income cannot exceed $2,130 per month. In 2014, those numbers go up a few dollars every year. Now, your client can likely qualify for the first criterion by giving assets away. The question is, what kind of assets are being gifted? If they're qualified funds, and if you're dealing with successful people, I would say at least 50% of funds in retirement portfolios are qualified, then there's an immediate federal and state tax. Now, if those funds are low-cost-based assets, then there is an unnecessary capital gains tax. Had the money been in the individual's name at death, there would have been a free, that's correct, step up to fair market value. The value of the investment at date of death would become the new cost basis. However, if your client is still inclined to gift assets, the next hurdle is income. If he or she has more than $2,130 per month, then that individual does not qualify in any state. If less, then the client will qualify, but then it's unlikely it's your client to begin with. Here's the long and short of it. No attorney who understands Medicaid will tell clients with assets and income that the waiver programs are a viable source to pay for care in the community. Such an attorney will tell the client that Medicaid is a viable funding source only for skilled nursing home care. Therefore, if your client's goal is to remain at home and the client has assets and income, here's the great news. Medicaid cannot and is not a viable source to pay for that care. Let's take a look at Medicaid eligibility. There are two criteria in every state: assets and income. Let's look at assets first. All states divide assets into three classes or categories. Category number one, countable assets. Some states refer to them as non-exempt, tomato, tomato. Now, assets in that column are considered available to be spent on care. The next category, non-countable assets. Some states call them exempt. Same difference. Whatever is in that column does not have to be spent. And the third column are inaccessible assets. They're assets in someone's name, but you can't get access to them. For example, stock in a closely held corporation. It's worth something, but if it can't be sold, it's inaccessible for Medicaid purposes. All right, let's start with a review of countable assets. Countable assets are any personal financial resources owned or controlled by the applicant for Medicaid benefits. Medicaid considers them available to pay for care. They include all investments, stocks, bonds, whatever it might be, real estate. Annuities, unless they've been annuitized, then the annuity is considered income. Let's stop there just for a second. So if you sold an annuity, and that annuity is deferred because sometime in the future you'll start taking income from it, for Medicaid purposes, that annuity is considered available to be spent on care. Cash value in life insurance, if the death benefit exceeds $1,500. A lot of people don't know that. It's not the cash value of $1,500 if the death benefit exceeds $1,500. Now, I have a whole life policy with a lot of cash value. If I were to apply for Medicaid, that cash value is available to be spent on care. All cash and certificates of deposit, money markets, checking, and other liquid funds. And finally, all tax-qualified plans are considered available to be spent on care. Now, that includes a 401k, 403b, SARSEP, IRA, you name it. Anything the client has put aside pre-tax to generate streams of income in the future, Medicaid says it's available to be spent on care. Now, the operative word is available. No state mandates that the funds we just discussed be used for care. So if the client or the client's representative says, we're not going to use them, there are too many taxes that are associated with using the money to pay for my father's care in a nursing home, Medicaid says, that's okay with us. Application denied. Let's move on to a primary residence. Now, pay attention here for a second. If the net value of a home, primary residence, your home, exceeds a cap, which is between $543,000 and $814,000. By that I'm saying the state has a right to set limits between those two. So if the value exceeds that which is set by the state and a spouse does not live in it, then that house disqualifies someone from Medicaid. Please, once again, check with your local Medicaid office. We now move on to non-countable assets. Now, non-countable assets, also referred to as exempt assets, are acknowledged by Medicaid but are not used in determining eligibility. They generally include what? That's right, the house, a primary residence, assuming that the value doesn't exceed the cap we just discussed. However, almost every state will place a lien on it to recover Medicaid benefits paid after the beneficiary or spouse's death. See page 55 for exceptions to that rule, and your instructor will go over it with you, I think, as well. The applicant is also allowed to keep a prepaid burial account, term life insurance, because there's no cash value, you can keep it. Now, whether or not you can afford to keep paying the premium is another issue, but they don't tell you to liquidate it. It's a non-countable asset. And a small sum of cash, that's called a cash allowance, usually between $1,500 and $2,000. Now we move on to business assets. If the applicant derives a livelihood from them, then they would be exempt. More on that further on in this chapter. All states allow you to keep a car for personal use, but you can't take $100,000 and buy an exotic car. You can't do that. So let you keep your car. They also let you keep personal items. And the final category of assets are inaccessible in nature. Now, these are assets that would have to be countable. They would have to be spent on someone's care, but the applicant cannot get access to them. They include, for example, stock in a closely held corporation, I just mentioned that, and accounts that require the applicant to give consent to disbursement, which the applicant cannot give because, for example, of dementia. In the latter case, the state gives the family a limited period of time to file a petition to obtain access. We now move on to the look-back period and ineligibility periods. Now, one option to get on Medicaid is to simply get rid of your money and wait for, that is correct, 5 years. So now we have to look at what the look-back period stands for. So the look-back period is simply a period of time used by Medicaid to review all transfers when an application for long-term care benefits has been submitted. The look-back period begins on the date of application. Now, all states use a 5-year period. So any gifts which are considered transfers for less than adequate consideration, any gifts create a period of ineligibility that begins on the date an application is submitted, not when they're given away, but when the application is submitted. The larger the amount of the gifts, the greater the disqualification. States use the following formula. Please follow it on the screen and in the course. All gifts made during that look-back period, okay, are aggregated. Let's assume that total is $100,000. That amount is divided by what your state considers the average monthly cost of a semi-private room to be. Believe it or not, every state has that number. Let's assume your state sets that figure at $5,000. So the total period of ineligibility would be 20 months, $100,000 divided by $5,000. So one option then is to simply give away all your assets and wait for 5 years. If that's what a client wants to do, rather than badmouth Medicaid, educate them about a number of issues, including immediate taxes on the transfer of qualified funds. By the way, you don't hear this at these free seminars on how to get on Medicaid. Taxes on appreciated assets, assets with a capital gain, see that's the positive difference, if any, between the acquisition price and disposal price, are not taxed if they appear in the individual's estate at death, so you get a free step up. However, if given away, they do incur a capital gains tax liability. Although it's delayed, it will be due because the kids picked up what? The low cost basis. If the goal of the plan is to stay at home, Medicaid cannot be a viable funding source. Okay, we've discussed what happens to an individual. We now move on to Medicaid treatment of a couple's assets. Now, all countable assets, stop there for a second, those are considered available to be spent on care, stocks, bonds, IRAs, KEOs, CDs, money market, whatever it is. All countable assets in a state-sanctioned marriage are considered jointly held and available to be spent on the institutionalized spouse's care, subject to certain spousal allowance limits. A provision called the Spousal Impoverishment Rule allows the community spouse, that's the person who is at home, to retain a certain amount of assets as well as income. We'll focus on assets right now. Beyond this allowance, all of the couple's assets earned by and held in the name of either spouse or jointly are generally considered countable. They're countable and available to fund the institutionalized spouse's care. The community spouse's assets are considered countable even if, very important now, there's a premarital agreement. No state recognizes premarital agreements. If the purpose of the agreement was to hold the assets separate, for Medicaid purposes, they're all joined together. Next, they're held jointly even if the institutionalized spouse never contributed to those assets. Even if the couple live in a community property state, which means assets brought into the marriage are generally not subject to division or divorce. Medicaid doesn't accept that either. There's an exception to this rule in some states. If the community spouse has a tax-qualified plan that currently prohibits access, it may not be considered as part of the institutionalized spouse's assets. Again, please check with your state to determine what its policy is on jointly held assets. All right, now let's look at what he or she is allowed to keep once they're at home. That's referred to as the CSRA, or Community Spouse Resource Allowance. All states take a snapshot of the couple's assets on the day a spouse goes into a medical institution or nursing home where that spouse is expected to stay more than 30 days. The community spouse, the person home again, gets to keep a certain amount of the combined countable assets calculated by the CSRA formula. Now that formula was established to allow the spouse at home to survive financially if his or her spouse needed skilled nursing facility care. The community spouse is allowed to keep half of the couple's combined assets, but no less than a minimum, or referred to as a floor, of $23,448 in 2014. Again, these numbers go up modestly every year. And no more than a maximum, referred to as the ceiling, of $117,240 in 2014. What does this mean? If the couple have, for example, $80,000 combined assets, she keeps 40. If the couple has 30, she would keep what? 23. See, she keeps no less than 23. Now, if the couple have $800,000, she doesn't keep $400,000. She keeps $117,240. Particularly devastating in second marriages. Now, states have a right to raise the floor. States like California and Massachusetts and Florida, and I think Texas, raise the floor from $23,000 to $117,240. So if the couple had $80,000 in Massachusetts, she wouldn't keep 40, she'd keep $117,240. You can see the example in the course. All right, let me give you an example that's on screen and you can also see in the program. Alan and Rebecca, both widowed, remarry. Prior to their wedding, they signed a prenuptial agreement to define what would happen to their separate holdings in the event of a divorce or death. Classic premarital agreement. Now, Rebecca entered into the marriage with over $500,000. Alan brought his home and $220,000 into the marriage. Now remember, it's not $720, it's $500 and $220. Well, unfortunately, Alan suffers a serious stroke that leaves him paralyzed. After 4 years of trying to care for him at home, Rebecca places her husband in a skilled nursing facility on January 1st, 2014. The snapshot of their assets on that date shows not $500, not $220, but $720,000. Again, please remember all the countable assets, regardless of whose name they're in, regardless of a premarital agreement, jointly held. Now, to qualify for Medicaid coverage, the couple will be required to spend down their combined assets to the maximum ceiling, ready, of $117,240. And once again, Medicaid will disregard the premarital agreement. This is absolutely devastating to the spouse who's at home, to the wife. They never planned it to be like this. That's what happens if one needs care. We now move on to income. Remember, that was the second criteria, assets, which we've explored, and now income. We'll look at income for individuals and then income for a couple. Now, all income, regardless of how earned or when received, is considered available to be spent on the Medicaid beneficiary's care. We're, again, assuming that he or she is not married. Now, there are 3 exceptions, or 3 deductions, if you will. All states allow a personal monthly needs allowance, generally between $30 to $75, For the amount, just check with your state or in the appendix in this course to cover such items as clothing, toiletries, and medical expenses not covered by Medicare. Obviously, you can't cover that much with $50 or $60. Now, the second deduction would be the beneficiary's Medicare Part B and Medicare supplement insurance premiums, if there is one, and other small deductions permitted by state law. All right, now let's look at something referred to as the spend down program. More than half the states employ a so-called spend down theory in which the beneficiary's monthly income with those deductions goes directly to the nursing home, with Medicaid making up any difference at its rate of reimbursement. Let's stop here just for a second. Now, generally speaking, Medicaid pays about 1/2 to 2/3 of a private pay rate. See, they generally lose about $25 to $40 a day on Medicaid. As I mentioned before, they make up that difference with Medicare Part A and private pay. Now, the only condition is that in the aggregate, the monthly income must be less than the private cost of a room. So if the nursing home privately is $6,000 a month and your pension is $7,000, no state says you're eligible for Medicaid. We now move on to a discussion of so-called income cap states. The remaining states cap the amount of monthly income a Medicaid applicant can have. Take a moment to review what those states are. Now, these states grant eligibility only if the monthly income of the applicant is at or less than a cap, generally $2,130 in 2014. Once again, as with all Medicaid numbers, they go up modestly every year. Now, those who exceed income caps do not qualify for Medicaid unless they establish, here we go, a qualified income trust, commonly referred to as a Miller Trust. I'll give you a primer of how it works. They're established either by the family of the applicant or a nursing facility for that matter. The trust must have the following provisions. The beneficiary is, that's correct, the Medicaid applicant. The beneficiary's income is deposited into the trust every month. The trustee then turns around and distributes to the nursing home no more than the cap, in this case $2,130. The applicant is now at the cap and can thus qualify for Medicaid. Now, the balance remains in trust and is paid to the state upon the beneficiary's death. Look at the examples in the course. If you have any questions, just certainly ask the instructor. We now finish up with income for a couple. The community spouse's monthly income is never used in determining the Medicaid eligibility of his or her spouse. The minimum monthly maintenance needs allowance. What's that? Since most couples applying for assistance have minimal income, the state and federal governments, which jointly fund Medicaid, as we discussed, have attempted to leave those in the community with a so-called livable allowance. You determine after we go through this situation whether or not that's livable. But the community spouse is allowed to keep a minimum monthly needs allowance, MMMNA. Now, the minimum needs allowance in each state has to equal at least a floor, which is $1,939 currently, and can be as high as a ceiling of $2,931 currently. For the needs allowance in your state, please check Appendix 4 or ask your instructor. Now, these rules apply only if the community spouse's monthly income is less than that floor. If, for example, her income is $3,000 per month, she gets to keep all of it but receives nothing from her husband because she's over that minimum of $1,939. Here's an example of how devastating qualification for Medicaid benefits is to the people who can afford long-term care insurance, the affluent. Example, Susan and Francis are in a second marriage. They have the following assets and income, and please feel free to follow in the course or ask your instructor at any time. Here are the asset breakdowns. Susan has a $150,000 IRA. Francis, her husband, has an IRA converted from a 403B, probably was a teacher, and that's worth $100,000. Susan has stocks worth $100,000. Francis has stocks and bonds worth $167,240. The total assets are $517,240. Now, that's considered the mass affluent. Successful people, they can keep their commitments. Why? Look at the income. Susan receives $25,000 from her IRA and Social Security benefit. Francis has a pension, and that's a 403B, I guess, He's got a pension of $52,000 and investment income, that's the drawdown of his IRA, of $15,000 per year. This couple is good for, give or take, $92,000. They're doing actually quite well. Now, since it's a second marriage, they have a standard premarital agreement stating that in case of a divorce or at death, their assets will go to their respective children, not to the estate of the survivor. Francis is diagnosed with early onset dementia in 2010. Now, after keeping him home for 4 years, Susan decides she has no choice but to make a placement in a nursing home. Here's what happens to their assets and income in a typical state. We'll use Massachusetts. Now, Medicaid takes a snapshot of the assets when Francis is admitted to a nursing home, as we discussed previously. Susan gets to keep 1/2 of the $517,240, but no more than a federal and state ceiling of, correct, $117,240, regardless of the premarital agreement. Her money is considered his money. The excess of $400,000, that's the difference between what, $517,240 and what she keeps, $117,240, is available to be spent on her husband's care, regardless of the premarital agreement. Once the couple is down to $117,240, Francis will qualify for benefits. Well, that is phase one. Phase two now is, what's her income and how much can she keep from her husband's income, if any? Now, by law, Susan can keep no less than the minimum maintenance and needs allowance of $1,939 per month or $23,268 per year. Remember that number. However, her income is $25,000 per year. She gets to keep the $25,000 but keeps nothing of her husband's $52,000. Now, here's the result of their relying on Medicaid on the basis of what they heard or were told by a lawyer at a seminar or whatever. The couple started with $517,240. All states cap Susan at $117,240. The couple started with $92,000 per year in income. Susan's left with her income of only $25,000. Let's stop there for a second. That is absolutely devastating. If you have clients who have income from what? Pensions, defined benefits, they never want to go on Medicaid. Look, I'm a Medicaid planning attorney. I'll get someone on Medicaid. I can get rid of the assets. It's expensive, costs you taxes, but I can get rid of them. No lawyer can get rid of income. They started with $92,000. She's left with $25,000. They started with $517,240. She's left with $117,240. So you've all heard of so-called Medicaid-friendly annuities. Can Susan annuitize the spend down? A lot of states give Susan the option of annuitizing the spend down, which in this case is $400,000, into a stream of income based on her age. Now, these states allow funds that otherwise would be spent on nursing home care, in this case, $400,000, to be transferred to the community spouse. Susan can then annuitize that into a stream of income under the following conditions. The annuity must be actuarially sound. That means it must be based on her life expectancy at the date of purchase. So if she's 75 years old, generally she can buy about a 7-year annuity. She can't buy 15 or 20-year. Now, it must be issued on a period certain basis only. Not life with a period certain, not life. But it must amortize 100% during the period set forth. The contract must be non-assignable and irrevocable. Now, while preferable to a spend down, annuitization does have its costs. Transferring assets such as an IRA to the spouse creates serious ordinary income tax liability. Liquidating an IRA and stocks creates capital gains, tax liabilities, and what if the funds are sold in a down market? So, think about the concept of annuitizing. You might have heard that it's a great concept on the radio and a seminar, but look at the consequences tax-wise, market timing, if that's the plan. All right, now we move to Medicaid planning. Why buy long-term care insurance? We'll just put together a Medicaid plan. Now, two things we'll focus on. Simply transferring the assets and waiting for 5 years or putting them in a trust. So a quick review of transferring assets. Medicaid planning is the practice of taking countable assets and making them inaccessible by either giving them away or placing them in trust. Now let's take a look at giving them away. Medicaid which is intended for financially needy, has in recent years severely restricted opportunities for both such planning. Let's look at giving assets away. Now here's a recap of the tax consequences of giving away assets for the express purpose of qualifying for Medicaid, a program that won't pay for care where you want it. So we start with transferring tax-qualified retirement or pre-tax plans. Well, that creates an immediate federal and state tax as high as 39.5% plus whatever your state income tax is. Now, there's a future tax liability created by gifting low-cost-based assets, which we discussed. Let's focus on your home. The transfer of a client or your home would, A, forfeit the capital gains exclusion for home sales. Remember, that's $250,000 per individual, $500,000 per couple. And B, saddle the recipient, the children, for example, with the grantor's low cost basis, thus creating a substantial tax on the sale of the property. Now, stop here for a second. Remember, if the stock, or in this case the house, were in the individual's name at death, you receive altogether, correct, a free step up. You forfeit that by giving rid of your money. All right, and then we end up with a review of transferring assets into trust. The second option used to make accountable assets inaccessible is to simply put them into a trust. A trust is a legal instrument or document established by an individual or couple to hold assets. The person funding the trust generally is referred to as a donor or grantor or trustor. Assets held in the trust are for the benefit of people referred to as, correct, beneficiaries, and one or more trustees manage the trust. All trust must have at least a donor or grantor who makes the initial rules of the trust and funds it with assets, and one trustee, that's the person responsibility for executing the demands or commands, and one beneficiary who will receive the benefit of the trust assets. Now, there are two basic types of trust in the world, those that are revocable or revocable, and those that are irrevocable or irrevocable. Let's take a look at revocable trust. Now, these are instruments that allow the donor, the person who set it up, to maintain control of the assets. He may modify or terminate the trust and is always able to receive the benefits of the trust at his or her wish. However, they're of no value whatsoever in protecting assets because all states take the position that if the applicant is the donor, assets in the trust are countable and therefore available to be spent on care. We now move on to irrevocable or irrevocable trust. An irrevocable trust bears many of the same characteristics as a revocable trust. The one notable difference involves the donor's control over it once it's been set up and funded. As the title suggests, an irrevocable trust, once established, may not be revoked or changed in any manner by the donor. He or she gives up control. Now, because of this characteristic, irrevocable trusts were widely used in Medicaid planning. To understand the issues involved in transfers to irrevocable trust, it's helpful to review the history of their use. So let's take a look at the use of these types of trust prior to 1986. The donors or the donor created an irrevocable instrument and placed assets in it. They named themselves not the trustee, but the beneficiaries. They named a family member as the trustee. They gave the trustee authority to distribute all or none of the principal and interest at the trustee's discretion. Now, the underlying assumption was that if one of the donor beneficiaries needed skilled nursing care and wanted to apply for Medicaid, the trustee, could be a child for example, would exercise his or her discretion and not make principal and interest available to the applicant, who again is the donor, that's the one who set up the trust. Now, here are the issues created by the use of trust. First up, a trust cannot hold qualified funds. Funding it with such creates an immediate tax liability. The trust is of no value while the person needing care is at home in the community because Medicaid pays only for limited, if any, custodial care. Once an applicant is on Medicaid, as previously explained, his or her community spouse loses most, if not all, of that applicant's income. Well, they may have worked, but Congress steps in. Now we'll review COBRA, the Consolidated Omnibus Budget Reconciliation Act of 1985. Here's where trusts stand as of that date. Congress restricted the use of such trusts in the Consolidated Omnibus Budget Reconciliation Act of 1985. It's referred to as COBRA 85. A trust would be classified as an MQT, a Medicaid qualifying trust, which you'll see in a moment means it doesn't work, if the trust is established by the applicant or the applicant's spouse other than by will. It can't be part of a will, it has to be established while the person's alive, and provides that either or both are beneficiaries. The trustee has been given discretion to distribute income or assets to either or both beneficiaries. That has to be in the trust. And if that's the case, Medicaid in all states will presume that the trustee will exercise whatever discretion was given to him or her. What does that mean? Well, if you give a trustee discretion to distribute assets, then Medicaid assumes that the trustee will do so and make those assets available to pay for care in a skilled nursing home. Wow. By the way, that legislation is retroactive. So what lawyers did was to get rid of the provision giving discretion over the principal, and now we go from between 1985 and 1993, so-called income-only trust. So attorneys like myself shifted their planning strategies away from income and principal discretionary trust and came up with, correct, an income-only instrument. The concept is simple enough. Set up the same type of trust that was prohibited in 1985, but leave one feature out: discretion over principal. Such income-only trust immediately became popular among Medicaid planners because the state could not force the trustee to distribute something which they had no discretion over, which was the principal. So they typically work like this. First, the donor creates an irrevocable trust and placed his or her assets in it. He names himself or he and his wife as beneficiaries. They name a family member as a trustee. Sound familiar so far? Now, they give the trustee authority to distribute all or none of the income. Stop right there. There's no discretion to distribute principal. That's why they're called income-only trusts. Now, if one of the donor beneficiaries, the person who set up the trust, and he is also a beneficiary, if he or she needed skilled nursing care and wanted to apply for Medicaid, only the income was available to be spent on him. And by the way, only half of it if there were two beneficiaries. Well, the law changed again under OBRA 1993, or OBRA 93. The 1993 Omnibus Budget Reconciliation Act again attempted to correct the perceived weaknesses of the 1985 law. Stop there for a second. OBRA and COBRA are basically the same thing. Congress dropped the C in COBRA, Consolidated Omnibus. They finally figured out that was redundant. So it's now called OBRA, and that's your federal budget. Now, OBRA 93 had several provisions, the most important of which are as follows. Expanded estate recovery. Undoubtedly, the most far-reaching section of OBRA 93 is the law mandating the states to implement estate recovery. Now, this undermines those who have income-only trust drafted after August 11, 1993. The entire proceeds of such a trust could be deemed available to repay Medicaid. The other issue created by OBRA 93 was the use of so-called life estates. Now, these are created when the owner of real estate conveys it to another person, usually a child or children, but keeps the right to live there and control what happens to the property during that person's life. Legally, the individual has conveyed a remainder interest, keeping a life interest, which is referred to as a life estate. That life estate obviously terminates at the death of the individual. Now, here's the good news about life estates. The entire value of the property is included in the decedent's taxable estate at death, thereby giving the children a step up of the property's cost basis to fair market value. If you do it right, there's no taxes due when the kids sell it. Here's the problem. Life estates are cast into doubt because many states are now starting to place liens on that interest. Once again, please check with your local Medicaid office or Medicaid planning attorney. And we finish up with something called trust to benefit disabled individuals. Now I'm going to take a look at something called the Supplemental Needs Trust. OBRA 93 allowed a disabled individual under 65 to be the recipient of a so-called Supplemental Needs Trust, also referred to generically as a Special Needs Trust, but technically they're called SNT, Supplemental Needs Trust. Now, the trust has to be set up for that individual child's benefit. Now, the following rules apply. The trust must be established for the sole benefit of the disabled person by a parent, grandparent, legal guardian, or a court of competent jurisdiction. If the trust is funded with a disabled beneficiary's own assets, it must provide that upon that child's death, the assets left will be given to the state to repay benefits. That's referred to as a so-called payback trust. A trust funded with someone else's assets, such as those of a parent, is not necessarily required to contain a payback provision. Again, please check with your local Medicaid office. Now, those supplemental needs trusts are for those under 65. If you're over 65, you can only use something called a pooled disability trust. Now, that joins the disabled person's assets with others to form a pool of funds. This has a number of advantages, including affordability. The disabled beneficiary does not have to spend money for a trustee to manage the assets. The trust is also useful, as again, for those over 65. Summary of Medicaid. Medicaid planning may be able to protect assets, but never income. By the way, you never hear that at a seminar, do you? Things to consider when the client suggests that his or her attorney told him Medicaid will pay for your care, you don't need long-term care insurance. Point number one, attorneys tend to focus on protecting assets, not income, which is essential to support lifestyle. Why do they focus on assets? Because no lawyer will tell you that they can protect income. Point two, attorneys tend to focus on shifting assets. Would they do so if those assets were tied up in qualified tax-deferred investments and or low-cost-based assets? Point number three, attorneys tend to focus on Medicaid's paying for nursing home care, not care in the community. They have to focus on nursing home care because they know the program will not pay to keep someone at home unless you have severely limited income. Remember, less than $2,130. If they have less, good luck, they're on Medicaid for home care, they're not your client. And then, next point, attorneys tend to focus on the quality of care the client will receive in a facility, not the impact that providing quality care will have on his family while he or she is in the community. So now let's give you a selling scenario, overcoming the objection, quote unquote, my attorney told me Medicaid will pay for my care. Now you can take a look at this in the course. I'll just read it out to you. I'll play both sides of it. All right? With few exceptions, the objection you might get is this. Quote unquote, my lawyer told me Medicaid will pay for my care in a good nursing home, or I know someone who had Medicaid pay for his care in a nursing home. Well, a simple set of questions can quickly overcome the objection and place the attorney who gave the advice on the defensive. Here, first question. Did the lawyer tell you that you could get into a good nursing home on Medicaid? The answer was yes. Stop right here. What would you have said before this course? Oh, you won't get into a good nursing home. Don't discriminate. Look at your new answer. The attorney's 100% correct. You'll get in a great nursing home in Medicaid. But see, here's the problem. The goal of the plan that I put together with your permission is to have you remain where, Frank? What's at home? That's correct. Did the attorney tell you that Medicaid would pay for home care, adult daycare, assisted living? Look at Frank's answer. Actually, he never said that. Well, because he can't say that. Now, did he also mention that you would have to gift all of your assets away and wait for 5? Yeah, actually, he did say that. No problem. Get rid of your money now. Wait 5 years. You qualify for Medicaid. You'll get in a great nursing home. Couple of thoughts. The problem is that it creates serious tax issues, Frank. Gifting qualified funds means an immediate tax of up to 39.6% plus your state tax. If you transfer low cost-based assets, the children will have to pay a capital gains tax when they sell them. However, your plan probably called to keep the assets in your name, so at death they receive a free step-up. One more thing. Did the attorney mention that once you qualify for benefits, Susan will lose most, if not all, of your monthly income? Frank says, you know something, you never mentioned that. Well, Frank, that's the deal. She will. So here's the deal. Medicaid is not a viable funding source for the plan I put together to keep you at home. There's nothing the program can do to alleviate the emotional and physical stress that taking care of you will cause your wife and children. There's nothing Medicaid can do to protect your lifestyle, which will be devastated because income will have to be what? Remember we talked about this? Have to be reallocated. And if the illness lasts long enough, it likely will threaten the financial viability of those people you invited into your life and said you take responsibility for. So, in summation, there's no need to ever speak disparagingly of Medicaid. Once you understand it, in reality, it helps you make the case for long-term care insurance. Look, thank you for spending some time with me. Please ask your instructor to go over particular points that you may not have understood. And if you have any questions, you can always email me at CLTC. Thank you, by the way, for taking the program, and I hope this has been helpful to you.